Welcome to our series of podcasts focusing on international employment law. I'm Aileen Murray, Senior Counsel in the Employment Team at Travers Smith, and I'm joined by Alex Fisher, a partner in the team. As you may know, in these podcasts, we've been speaking to friends from law firms in a variety of jurisdictions and asking them about the key employment law issues and the things to think about when employing staff in their country. For each jurisdiction, we'll be doing 3 short podcasts, one covering the start of employment, the second covering the end of employment, and the final one covering other key aspects of employment law in their jurisdiction. And today we're delighted to be joined by Åsa Gotthardsson from Vinge in Sweden. Vinge is a leading full-service Nordic law firm with a first-class employment team. So welcome, Åsa.
Thank you.
And so in the first podcast, we're looking at the start of employment, and I'm going to hand over to Alex to kick things off.
Thanks, Ailey. So our first question for you, Åsa, is what are the key things to think about from an employment law perspective when advertising vacancies in Sweden?
Yes. So to start with, perhaps before you would advertise a vacancy, is to consider whether anyone in the organization is entitled to priority to re-employment. And that means that there might be individuals that has been employed before and been given notice of termination due to redundancy. And those employees, if they are qualified, given that they have worked for 12 months or more before the redundancy, they have a priority to be re-employed during the notice period and for 9 months thereafter. And if that's the case, and the individual has qualifications for the position that is being advertised or the open vacancy, the individual should be, in fact, offered the role rather than it being advertised. And secondly, so when you do make an advertising of a vacancy, you should make sure that the advertiser in itself isn't discriminating, so that you're not saying that we prefer females or disabled employees do not bother. I mean, no one write this, of course, but to give you very clear examples, but that is also important. Otherwise, I would say that we don't have very much of applicable legislation for the advertisement itself. Another thing that is important to note when in a company with a collective bargaining agreement is that hiring a manager is a question that should be consulted before sort of the profile and the individual is chosen.
Okay, brilliant. Thank you. Is there anything that employers should avoid asking candidates in Sweden? So people that are applying for the roles, is there anything that should be avoided?
I mean, there is no prohibited questions, really. However, I guess, as many other countries would say, that questions that risk being seen or perceived as discriminating should be avoided. So asking a candidate whether she is pregnant is essentially fine, but the risk is that the candidate feels that the decision then to not go forward with that individual was based on the answer to that question, of course, if the answer was yes. So we would instruct employers to avoid any such questions.
Yeah, and that's very similar to here. That's, exactly.
Yeah.
You just avoid those things. And we often see employers want to carry out kind of background checks and employee screening. Is that something that's usual practice or permitted in Sweden?
Yeah, so it is permitted. I wouldn't say it is usual practice except for managers, so sort of management team, or perhaps only the CEO, and also depending on if it's a listed company, perhaps also sort of selecting people to the board could be subject to a background check, but it will become more usual. We're noticing that sort of day by day or week by week, actually, So more background screening and background checks will be carried out, definitely, and they are permitted.
Okay, great.
Perhaps one addition there, because when we review employment contracts drafts from the UK, we often see that the contract is, or an offer letter for that sake, is intended to be signed, and the background screening is then happening afterwards. So our recommendation would definitely be to have the background screening made before offering the actual agreement, because if the employment agreement is sort of sent to the employee and it's possible for the employee or for the candidate to sign, that could be a binding agreement and if there's no probationary period, the outcome of the background screening is not necessarily a ground for termination. So that is, of course, an important difference.
Would that be the case even if you set the contract up to say that employment will start on a certain day, subject to appropriate background screening or references?
Exactly, yeah. So there is a risk that the employer could back out of such agreement if it's signed due to the outcome. So if someone said that I have a driver's license and that individual is supposed to be driving at duty, of course, that knowing then that the employee doesn't have a driver's license would probably be cause for termination of the agreement. But typically there's other things, perhaps more from a soft perspective, or even criminal records, that is not necessarily a legal ground to sort of back away from a signed agreement.
Okay, that's interesting. Thank you. What about if you're recruiting an employee from a competitor? Does that give rise to any particular issues?
I mean, I think that was an interesting question, which I'm not sure that employers in Sweden are really taking too much consideration into. But I think a question is interesting, and I would definitely say that if I was to employ someone from a competitor, I would make sure that employee knows about the Trade Secrets Act and the fact that the new employer would be sort of liable for a breach of the act if the company would, or if the trade secrets would be used in the new business. So it's not only the employee that risks being in breach of the act, but also the new employer. So having a discussion regarding that, depending on the position perhaps of the employee, and also of course if there are restrictive covenants. Contrary to other countries or some other countries, there's no sort of hiring someone with a restrictive covenant is not a breach of any legislation, but so it's possible to sign an employment agreement, and it is basically up to the employee to make sure that the employee doesn't say he or she can start before the end of their restrictive covenants, at the end of the restrictive covenant. So the employer really doesn't really sort of make any breach. However, what could be a potential liability is if the new employer says that, don't mind the restrictive covenants, we will pay any damages, or we will pay any liquidated damages. So you will not be in sort of a financial situation if we were to employ you. So come over, start working. That could be sort of it's not a natural cause by the legislation, but it is sort of, there are case law from the highest court in Sweden making statements that has made us draw the conclusion that a potential liability could be there.
That makes sense, and that's kind of, we have the concept of inducing breach of contract. So if the employer, if an employer encourages an employee to break their existing restrictive covenants, then the new employer can be kind of in some hot water in those circumstances. That sounds potentially similar to that.
So that's actually legislated in the UK.
Yes,
Yeah.
through
Yeah.
people.
Yeah, it's a tort of inducement. So yeah.
Right. Interesting.
And so finally, once an employer has they've chosen their candidate, what do they need to be thinking about in relation to documenting the terms for that employment?
Yeah. So also from experience working with UK companies, we don't use we don't use offer letters in Sweden. So the risk with using an offer letter being followed by an employment agreement is that the offer letter itself is seen as the employment agreement. So if there's restrictions in the actual employment agreement that the employee not necessarily is so keen on signing, he or she could claim, if we would disregard the practical difficulty to then start to have a relationship after that, but legally at least, the employee could say that I don't want to sign the employment agreement. I already have an employment agreement, which is the offer letter. So we would not recommend using an offer letter for a Swedish employee unless it's sort of an email or a formal document saying that, or sort of an informal document just specifying that these are the main terms we discussed on our phone call, which we would like to offer you an employment, and specifying really clearly that an employment agreement will be the actual entering into the employment agreement. So by saying that, a written employment agreement is recommended, and that it's very clear on the type of employment that is entered into. So if nothing is stated, it will be seen as an indefinite term employment. So if there's a fixed term employment agreed, that should really be specified clearly. And of course, any other key terms or employment terms would be included in, or is recommended to be included in, the employment agreement.
That all makes sense. That's been really helpful. So thank you for that. That concludes our Start of Employment podcast. And so please join us in the next podcast when we'll be covering the end of employment.